see that people are starting joining the webinar. We will wait for about 20-25 people to join, and we'll start the discussion. Just briefly, while people are joining, I think everybody knows, of course, why they're joining this webinar, so there's no harm for me to say again and repeat that today we're talking about cross between arbitration and insolvency in practice, and we will specifically discuss BVI arbitration cases, court cases about interrelationship between arbitration and insolvency proceedings. And let me introduce our speakers today, distinguished speakers. So Arabella Diorio, she worked offshore for over 20 years. She's a fellow of the Chartered Institute of Arbitrators. She specializes in BVI litigation in the BVI. She focuses on complex international commercial litigation arbitration, including insolvency, shareholder disputes, and trust. She regularly takes appointments as an arbitrator and mediator, and she has participated in one of the cases that we will discuss. And she also appears as an advocate in front of BVI arbitration courts. The next speaker is David Alexander QC. He's joint head of chambers at South Square. His practice predominantly focuses on litigation and arbitration matters, with an emphasis on company, commercial, banking, insolvency and restructuring, civil fraud and contentious trust work. He often appears in the courts in Bahamas, Bermuda, BVI, Cayman Islands, Jamaica, Jersey and Gibraltar. John Rooney is our special guest who has extensive arbitration practice. He's located in Miami and has more than 25 years of practical experience in international commercial law. He speaks fluent English, Spanish, and Portuguese, appears often in arbitrations, both as an advocate and takes appointments as well. He arbitrated under many different rules, including exit arbitration, ICC, ICJR, LCA. He is also an ancestral specialist, and he is part of the master's program of the University of Miami School of Law. And the last our speaker is Andrew Willins. He's a partner and group head of the dispute resolution department in the BVI. He has over 15 years of experience as an advocate. And he used before to be in the bar in London. He has particular experience in insolvency litigation, shareholders dispute, and complex commercial litigation. He also acts in cross-border fraud matters and asset tracing claims. And just before I hand to the distinguished speakers, I wanted to mention that one of the, of course, the name of this event is Arbitration Insolvency Wars Post Lenox and Rangecroft. And in one of those cases, Rangecroft, I represent Conyers and moderate this event. We participated on one of the represented one of the parties. And that was a fascinating case, which we will discuss today, which raised this whole debate in BVI community. What shall we do if the parties have agreed to arbitrate the dispute, but then there is a question of whether the debt which is due under the agreement is actually disputed. So just to start with, I would like to ask John Rooney, can you tell us what the issues arise in those matters where we have both arbitration and insolvency issues mixing up?
Jane, first of all, thank you very much for the kind word. Just a moment. Oh no, sorry, I just got a blank screen on my computer.
We don't see you. John, can you hear us? hope we have not lost John. I can see that he has camera and microphone, but it appears that we are not hearing him. So with all respect, we can probably ask David to
I'm very sorry. At a critical moment, I lost the connection, but it's back.
No problem.
Hopefully there won't be another problem. I just wanted to say, first of all, as I said, thank you for the kind words of introduction. And also note that I come at this more from the perspective of arbitrator and an attorney involved in pretty much all facets of the arbitration process. I'm not per se an insolvency specialist, but clearly the more that you operate in the commercial field, the more likely it is that you do encounter issues of insolvency and their interaction with arbitration. And that has also been my experience as well. I would also mention that I've been privileged in terms of my experience to act as an advocate in an arbitration before the center. I was involved with the successful recognition and enforcement of an award in BVI issued out of Miami some years ago, and was also involved, at least tangentially, in one of the cases that we'll be talking about today. Looking at the interaction of the two from the point of view of a, I guess I would say, of a more generalist, the issue that I see is the role, if any, that the requirements of the New York Convention with respect to recognition and enforcement of an award have with respect to the local insolvency regime. And in a sense, the local insolvency regime is, in its essence, a very local procedure. And of course, the procedure set forth in Article 5 of the New York Convention, it represents one of the accomplishments of the convention, which was a narrowing of the grounds for deciding how it is a competent authority can decide not to recognize or enforce an award. In the context of insolvency, I think we deal with recognition more than enforcement. In other words, the question is there a requirement when a jurisdiction is a contracting state of the New York Convention, or in the case, I think, of BVI, where the New York Convention, I believe, was extended by the United Kingdom to BVI, where there is a requirement with respect in an insolvency matter to follow the steps and consider the defenses set forth in Article 5 of the New York Convention with respect to recognition of the award. I think that the argument could go either way. The issue, my one experience in the BVI with that issue, the judge in fact said, if my memory is correct, that he was not going to consider himself bound and obligated to do so, but in fact what he did was, in a practical sense, go through the defenses of the award. The other question, looking at the BVI from abroad, from afar rather, is in that particular case, it was an award issued in England. Is, for the purposes of the BVI, an award issued in England considered to be a foreign award? I mean, that issue didn't come up in that case, but it's one I think that needs to be considered because of the special relationship I think that BVI would have with the United Kingdom. But in any event, I think it's the question of intersection of the two practice areas in the two disciplines is inevitable, and I think will only grow over time. I think there's still a lot of room for the development of jurisprudence in the area, and of course that's going to be one, I think, of the primary issues that we'll be talking about today. With that, Jane, I can turn the microphone back to you, and I guess we can move to the second speaker, unless you have another question.
Thank you, John. Thank you. That's very informative. But I think we have here one problem because of the Sparkasse case, which I would like to ask David. How do you think, that case? What is the relevance of that case to the topic that we are discussing today?
Well, from my perspective, I mean, it seems to me the relevance is Yes, sort of. Sparkasse, or to give it its full name, Sparkasse Brigands Bank and Associated Capital Corporation, was a decision of the Court of Appeal in the BVI in 2003. Sparkasse itself was an Austrian bank. Associated Capital was a BVI company. Sparkasse said that Associated Capital owed it $430,000. So Sparkasse presented applied to have a liquidator appointed in the BVI against Associated Capital. At first instance, the judge dismissed the petition to wind up Associated Capital. The judge said that there was a genuine and substantial dispute as to whether the debt was due. And we all know where that is the case, a petitioner cannot proceed. The judge also held that under the terms of the contract, a court in Austria had exclusive jurisdiction to resolve any legal dispute arising out of the agreement, and that a liquidator would only be appointed, or could not, a winding up order, the way I look at this, a liquidator couldn't be appointed until the court in Austria had actually decided the dispute. Sparkasse took that to the Court of Appeal, and the Court of Appeal said what I would regard as the usual stuff, namely that the court will wind up where there is no dispute, but it won't do so if there is a substantial dispute, although if that is just as to the amount of the debt and there is evidence of insolvency, the court would also wind up a company. As regards the substantial dispute, the court said that the dispute must be genuine in both an objective and a subjective sense. Or putting it another way, the reason for not paying the debt must be honestly believed, and the dispute must be based on substantial or reasonable grounds. Now, on the facts, the Court of Appeal determined that there was a dispute, and that since there was a term of the contract saying that the Austrian court had exclusive jurisdiction, the dispute had to be dealt with in Austria before winding up proceedings could be dealt with in the BVI. Now, logically, one might think that the same principles ought to apply in all cases where there is an arbitration clause. In other words, if there is an arbitration clause, then provided there is a genuine and substantial dispute, but only if there is a genuine and substantial dispute, that should be resolved in arbitration first before one can apply for a liquidator to be appointed. But, as I think we're going to come on to see, there are other cases where the test as to what the position is when there is an arbitration clause seems to be somewhat different.
Thank you, David. And Andrew, there is a case in the jurisdiction, well, it was decided by the Privy Council in 2016, vendor traders against Everstroy on appeal from the BVI Court of Appeal. What is the relevance of that case to our discussion?
I think it probably rather depends on who you ask, but there are two strands of logic that arise out of the case. On the Sparkasse test, which wasn't actually referred to in the Privy Council at all, it was dealt with very shortly indeed by Lord Sumption, who simply said that the Sparkasse test is another way of saying, is there a substantial dispute, is to be equated to the summary judgment test. Now, I think that perhaps came as a bit of a surprise to many people, because the Sparkasse test had always been seen as really quite a low bar, where it's necessary to show only that there's a prima facie case which should be allowed to go on, so perhaps a little lower than the summary judgment test. There was then a second strand of logic which arose out of the case, which arises out of what John was just saying. And that was this: what do you do where there is a foreign arbitral award? Is it necessary to go to the court first to get that recognised and enforced. And the Privy Council were pretty withering, it has to be said, of the suggestion that you do. They call that argument misconceived. And they said that as soon as you have the foreign arbitral award, what you have is an enforceable liability. And of course, once you've got an enforceable liability, you've got an admissible claim in a liquidation. And there are many cases, I know, Jane, you're familiar with one of them, Donna Union and Khashoggi, for instance, where the court has made winding up orders subsequently on the basis of arbitral awards without some form of recognition process under the Arbitration Act being deployed first.
Well, that's a very good point. And John, back to you. So what is the role of, I know you already touched a little bit on that, of the New York Convention here. And we have, I think, on this point, Kirkland case in the jurisdiction, which was decided by Mr. Justice Jack in 2019. So what is your view? What is the place of that convention determination whether a foreign award qualifies as a debt under local insolvency law?
What I would suggest, and I'm not sure that it's really been looked at from this perspective, right? The Article 5 of the New York Convention, basically, as I said, sets forth 7 categories of defenses to the recognition of an award that falls under the convention. That can be an award that is issued in the jurisdiction in which recognition is sought if the jurisdiction by legislation has decided that that's an award not considered to be domestic under the convention, or it can be an award brought from another jurisdiction. I think if you read carefully Article 5, I'm not so sure that Article 5 would require an ancillary proceeding, because the reference is not to the court, the reference is to something called a competent authority. And so the question, I think, might be, and maybe a way to phrase this issue point forward, I'm not sure that it always has been this way in the past, right, is that it would simply be a test that the authority that would determine whether or not, in fact, it is a debt would check the box with respect to defenses. I believe in Kirkland that is what Justice Jack did do. Kirkland, I think, is not in every sense the best example, because I think that the question of whether or not there would be a role for the New York Convention didn't arise procedurally until late in the case. If it had been, I think, raised at the beginning, there might have been what I would call a cleaner application of the convention. But my thought is that if you look at Article 5 as simply a legal test rather than, for example, an ancillary proceeding, because the reference, as I said, is not to court but the competent authority, that might be a way for integrating the two. Now, one of the problems with disregarding Article 5 would be the possibility that the state in which that occurs might be violating one of its obligations under public international law under the convention. And I think probably not so relevant for BVI, because I'm not sure, for example, that BVI is party to a lot of treaties for the bilateral protection of investment, for example. In other words, I don't think you'd have a lot of exposure in BVI. But in another jurisdiction, if you disregarded it, right, and if the result was adverse to the party that felt they should have been able to raise those defenses, they might inadvertently be triggering a claim under one of those treaties. And there was an ICSID case involving Bangladesh, in which Bangladesh was held to task for the acts of its court system with respect to how it handled New York Convention obligations. I think probably that kind of frames my feeling about it anyway. The idea, first, that Article 5 doesn't require a separate procedure, but it's an instruction to the competent authority, whatever that might be, wouldn't necessarily have to be a judge in a separate proceeding. It could be whatever the local law required. And I think it would be possible to integrate the two. And I think in terms of security from the person looking at the jurisdiction from afar, right, that would give an enhanced sense of, I guess, what they would call down south, a sense of juridical certainty or predictability with respect to result.
So John, am I right understanding that you are suggesting that there may be some room for thinking whether that particular Article 5, defenses, if you like, should be integrated in the insolvency law, in the local, process, or like there should be some basically kind of a checklist included in the rules, so that, as you say, that would be like an informed kind of an informed decision, or like all the parties will be on the same page.
And I think that would work. And actually, if you look at the 7 categories of defenses, right, they're pretty much neutral defenses based on questions of due process. The capacity of the party to enter into the clause. Was the clause invalid? Did the arbitrator act in a way that was somehow prevented a party from raising its defense or making its case? And the other bases in the convention, I'm not sure that they would be incompatible with an analysis of the presented debt, right, to the authority, because there has to be in any event some process of validating that debt, right? Even if it's just saying, here is a copy of the award certified, and then if the authority says, okay, that's enough, that in and of itself is a kind of a broad brush, but it is a review of some sort with respect to the adequacy of the presented debt for treatment as such under the local insolvency.
Thank you very much. That's all very interesting thoughts. Just meanwhile, while we proceed, if there are any questions from the audience, please feel free to post them in the chat. We will, if there is time, we will answer them at the end of this discussion. But if not, there's no time, feel free to send them to the panelists. So Arabella, I know you've been involved in one, very kind of controversial case, which created controversy, where we've been also involved, Conyers, the one Rangecroft against Lenox International Holdings. Also there was another case quite soon decided by the same judge, Mr. Justice Jack, which is a fair cheerful case. So could you tell us more about those cases? What new, why are they controversial? What is all this about?
Well, I think it's always good to be woken up and taken out of one's comfort zone. And I think there we were in the BVI, all feeling pretty comfortable that we knew what the position was in relation to this sort of thing. And just setting the scene again for everyone's benefit, we've slightly moved away from it. What we're talking about is a situation where there's an alleged unpaid debt. The underlying agreement contains an arbitration clause, and a winding up application has been issued. So there was a divergence between the positions in England and the position in the BVI. And the position in England is set out in the decision in Salford, which is where you have an arbitration provision. It is generally the situation that the court will send the dispute off to arbitration. And it is only in what the court in Salford described as wholly exceptional circumstances that the court should not do that. And those wholly exceptional circumstances are apparently so wholly exceptional that the Lord Chancellor in Salford couldn't actually come up with a single example. Now in the BVI, the position is slightly different. There is the same mandatory stay section in our Arbitration Act. And it is also the case that those provisions do not apply to winding up proceedings. But the position for a very long time as affirmed by the Court of Appeal decisions in C-Mobile and Jinpeng, was that the court had a duty to carry out a preliminary investigation of the facts, to have a look at whether the dispute that the debtor was raising was raised on genuine and substantial grounds. In other words, whether the test in Sparkasse, which David has just been talking about, was met. And the view in the BVI had never been that having to meet the Sparkasse test was somehow onerous for a debtor, which is how the court in Salford looked at it. And the court in Salford said that their rationale there was to ensure that creditors did not bypass an arbitration agreement by presenting a winding up petition. And the court saw that as putting a lot of pressure on a debtor, giving him the choice either to pay up or to have to prove that the debt was bona fide disputed on substantial grounds. So I think that's where things had been for a very long time. And then Lenox and Rangecroft came along. To all intents and purposes, it had the hallmarks of the standard case I've just been describing. The debtor company had defaulted on a loan agreement. The loan agreement contained an arbitration clause, and the creditor had applied to wind up the company. The debtor asserted the debt was disputed and also had cross-claims against the creditor. The creditor scoffed at all of this, said the defences and the cross-claims were completely bogus. And then when you look at the judgment, you will see that the court goes through the standard authorities that I've just been mentioning. So far, so good. But what then happens is that the court focuses on the fact that the creditor has not served a statutory demand before issuing the winding up proceedings. And that is the basis upon which the court distinguished Lenox and Rangecroft from the earlier decisions. Now, the court acknowledged that a statutory demand was not mandatory under the Insolvency Act, but said that if you go ahead without one, that's not something that the court encourages, save in what it referred to as appropriate cases, because it saw the winding up process as a two-stage one, and stage one had to involve a statutory demand. And the court was also looking at the fact that in Lenox and Rangecroft, there didn't seem to be any other creditors. And so the court looked at that as being a reason why it shouldn't attach as much weight as it might otherwise do to the winding up process being a collective remedy rather than an enforcement process by a particular creditor. And you will also see references in the judgment to the fact that the court saw engaging the Sparkasse test as prejudicing the debtor. The court said it was only because a statutory demand had not been served that the matter hadn't automatically been referred to arbitration. So you can see shades of Salford creeping in there. And the court said because that two-stage process had not been observed, the matter should go off to arbitration, but solely on the Sparkasse question. And only on condition that the arbitration would be a quick one. So you can see that was quite a remarkable change to the landscape that we'd all got used to. And particular features are the notion that if you haven't served a statutory demand, you have to have a good explanation as to why not. That the court won't, in fact, carry out the Sparkasse sniff test if there's an arbitration clause. So that in its eyes, it's ensuring a creditor doesn't steal a march by not serving a statutory demand. And it'll come as no surprise that creditors, of course, and this has always been seen as a creditor-friendly jurisdiction, saw things rather differently. And from their perspective, the position had been, why waste time on a statutory demand? And I accept there may well be cases where a statutory demand is a very useful tool. But why waste time on it when what you're doing is encouraging the debtor to issue an application to set it aside on grounds which, in your view, are never going to pass the Sparkasse sniff test, but which potentially can delay the winding up for weeks, if not months. you might as well go straight to winding up application, and the court will undertake your Sparkasse sniff test right there. And also in the background were these new points about how many creditors there are, is it more than one, and how many more than one, and the speed of the arbitration. How does that impact things? Would it matter if the arbitration was not going to be a quick one? So there, I think things were after Lenox and Rangecroft. We're all sitting up and paying keen attention. And next you get the delightfully named Fair Cheerful case. Now that had a very similar factual matrix to Lenox, and no statutory remand had been served there either, but the debtor had already commenced an arbitration. And there you will see the court maintains its stance with regard to the desirability of a statutory demand, asks the creditor to explain why one hasn't been issued, and says there's no good reason that's been put forward for undermining the two-step process of the insolvency regime in the BVI. And the court yet again refuses to engage on the Sparkasse test. There's a slight movement there, and there is an express acknowledgement that the Sparkasse test could be important where there is more than one creditor. And that is because in the court's view, the petitioning creditor could then fairly be seen as exercising a statutory right belonging to all creditors. But if it's just the one creditor, then it's unrealistic for that creditor to present matters as a collective remedy. And that one creditor should be held to the bargain it struck, namely that all disputes should be referred to arbitration. A little bit of light is shed on the speedy arbitration, and that seems to bear on the approach that the court will take to the winding up application that's already been issued. And the court said it had imposed the condition of a speedy arbitration in Lenox because the debtor there seemed a little bit reluctant to have the matter arbitrated. And so if the arbitration is going to be a quick one, it seems the court is more likely to stay the underlying winding up proceedings. But if it's going to be a long one, as it seems the one in Fair Cheerful was going to be, then there shouldn't be a stay and the winding up proceedings should be dismissed. Now, that's of course not the end of the story, because I think David is now going to take us into a fantasy land where some of the issues in Lenox and Fair Cheerful have been slightly refined, if not considerably refined.
That's right, Arabella. Thank you so much. That's a brilliant critical summary, if you can call that way, of what was going through all the heads of the BVI practitioners. And your, kind of presentation just a source of many other questions which arise, to which extent the court can actually impose anything in arbitration and so on, if it's a parties' agreement. David, I know that the next case that I will ask you about, the anonymous case, Andrew participated in that case, did some good job for us all to persuade the court to look at a different angle to these cases. So David, what that case adds to all this debate, the case is called A Creditor Against Anonymous Company Limited.
Yeah, I mean, it certainly does add something to it. It comes much closer to what I outlined before in the Sparkasse case, but it doesn't go all the way. But it seems to go some of the way. Now, as you said, this case has an absolutely magnificent name at the moment, A Creditor v. Anonymous Company Limited. It's not very revealing as to who was involved in this case at all, and it's quite plain that nobody wanted it to be known that they were in fact involved in it. In this case, A Creditor, and that is actually the name of the party, according to the report, applied for the appointment of a liquidator over Anonymous Company. It was based on a debt of $38 million US. Much of the debt, I think about 29 million, had been admitted, but there were discrepancies as to some part of the debt. And there was a provision saying that all disputes had to be referred to arbitration in Hong Kong, and is usually the case. The company had, of course, referred the matter to arbitration. That having happened, a creditor applied for the appointment of a liquidator without having first served a statutory demand. As Arabella has indicated, that if it had served a statutory demand, the court would usually have referred the matter to arbitration. But that was not the case if a creditor went straight to the application for the appointment of a liquidator. Now, Mr. Justice Jack said that in general it would be wrong to allow an applicant to bypass Section 18 by not serving a statutory demand. And he said that where there were no other creditors apart from the person applying for the liquidator, applying the Sparkasse test would undermine the policy of the Arbitration Act. But, and this is the important bit, he said that the court should still examine whether a proposed defence was advanced with any belief in its substance. And in this anonymous case, he decided that there was no substance to the defence and that it was just a put-up job. And on that basis, rather than staying or dismissing the application, he appointed liquidators without the matter having to go off to arbitration. So here, you don't have the Sparkasse test being applied, but equally, you don't have a test that essentially says that if there's an arbitration clause, then you can't present a winding up petition, because if you do, the matter will be sent off to arbitration to determine whether there's a substantial dispute. I mean, at the very least, if you present a winding up petition on the basis of this anonymous case and there is an arbitration clause, the court will at least want to be satisfied that any defence is advanced with belief in its substance. So that's a part of, if you like, of what was in the Sparkasse test, not the whole of it, as I said. The court will want to be satisfied that any defence is advanced with belief in its substance. And if it's not, the court will not send it off to arbitration, but it may well appoint a liquidator instead, as is exactly what happened in a creditor and anonymous company.
Thank you so much for overview of this important case for our jurisdiction. And I would like to ask Andrew, who had the benefit of participating in both cases, the anonymous one, he only knows who are the real parties, and the Rangecroft case as well. So Andrew, and actually, I would like to address this question to John as well. Andrew and John, what do you think? Does this all promote arbitration or discourage arbitration? And Andrew, maybe you can go first.
I think, again, it depends a little on who you ask, whether it encourages or promotes arbitration. I think the starting point, though, is Arabella mentioned a case called Jinpeng, which, of course, was the BVI case that refused specifically to follow Salford. And in Jinpeng, it was said that the court retains the discretion where there's an arbitration clause. In that case, it was exercised in favour of appointing a liquidator. And one of the features there was that the company was being mismanaged. And I think it's quite interesting, Jane, just to answer your question, to look at the subsequent judgment in the same case, because that picks up the story in Jinpeng about what happened next. And what you see is that after the winding up petition was initially dismissed by Justice Bannister and then restored by the Court of Appeal, arbitral proceedings were issued. And like in a creditor and anonymous and in fair cheerful, that was a Hong Kong IAC arbitration. That arbitration took 14 months. It cost $2.389 million. And on the morning of the hearing, the company turned up and said, surprise, we're not defending anymore. The words, we're throwing in the towel, came up in submission. So I think many people would say that's 2.389 million that might have been better retained within the company's coffers, so that it could be distributed by the liquidators to the unsecured creditors. So depending on who you ask, I'm going to carefully avoid giving my own view, not least because in a creditor, an appeal was filed yesterday, so I should probably steer clear of it. But one of the arguments that we advanced in a creditor is that it actually undermines arbitration rather than promotes it. And the reason is that if you are the lawyer that's drafting these loan agreements and the financing packages, what are you going to say to your client where there is a BVI law clause in the document? Are you going to say that there should be a jurisdiction clause, or are you going to say there should be arbitration clause? And as I say, if you're acting for a creditor, I would imagine that the answer is probably that you're going to say there ought to be a jurisdiction and not an arbitration clause, so that you avoid the line of logic that we've seen running through these cases.
Thank you. And John, what do you think? Do you have similar views, or what is your perspective? I think you're on mute. John. Yes.
I can't. Obviously, I can't get into the detail of BVI jurisprudence. All I would do is reference, once again, looking from afar, that the question of whether or not the arbitration agreement should be executed or not, unlike what we talked about in Kirkland, which was really, in terms of the New York Convention, the Article 5 defenses to recognition and enforcement of the award. In Article 2 of the convention deals with the arbitration agreement. In Article 2, just a second, Article 2, Section 3 effectively says that a court of a contracting state, when seized of an action in a matter in respect of which the parties have made an agreement within the meaning of this article, meaning an arbitration agreement that meets the specific general requirements of the New York Convention, shall at the request of one of the parties refer the parties to arbitration, unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. Once again, looking from afar, my only suggestion would be that there might be a place also for looking at the requirements of Article 3, Article 2(3), and the affirmative defenses to referral to arbitration. In other words, in the case of insolvency, when there is a clause, but the clause has not been executed, does the institution of insolvency render the clause null and void, inoperative, or incapable of being performed? Once again, from my mind, it's just a question really of framing the issue, I guess would be how I would say. And when I look from afar to the jurisdiction, I would see that possibly there could be a place for the requirements of Article 2, Paragraph 3.
Thank you so much. So far, we talked about all the issues which arise before the liquidator appointed. But I would like to ask the panelists a couple of questions, and especially David. David, what do you think? Shall a company, once it is already went into liquidation, is the liquidator, should he proceed with arbitration, kind of arrangements between the parties? Or should the insolvency law apply? What are your thoughts on this?
Well, you have two sort of parts to it, don't you? I mean, and I suppose which of these prevails, arbitration or insolvency, sort of rather depends. I mean, let's assume you have an ongoing arbitration with the company that goes into liquidation. Can that continue? Well, possibly. I mean, obviously in compulsory liquidation in BVI, you have a statutory stay, so prima facie, an arbitration against the relevant company would come to a halt because no one can proceed with any action or proceeding against the company with effect from the commencement of the liquidation. And I think one would have to assume that in most cases, it's going to be quite difficult to carry on dealing with the arbitration if the company in question is the respondent. But if the arbitration is near its end, then it's possible that the liquidator will agree to it being concluded on the basis that that's going to be the cheapest and most efficient way of getting a result between the parties. Or indeed, you can ask the court for permission to conclude the arbitration if the liquidator says he doesn't want to carry on. But on the other hand, if the arbitration has barely started, then it must be unlikely that either the liquidator will agree to it carrying on, or that you will be able to persuade a court to allow you to carry it on. I mean, obviously, each case is going to turn on its own facts, and what everyone should be looking for is the cheapest and most efficient way of getting a result. As regards the other side of the question, where you have the company bringing the arbitration, I mean, that again is going to depend on how the liquidator wants to proceed. And he's really got two choices. If he or she wants to go on with the arbitration, then it seems to me there's no problem with that happening. But if he or she says, well, I don't really want to go on with the arbitration, and the company is effectively the claimant in that arbitration, well, you'll have a situation where the liquidator is effectively defaulting and withdrawing the claim in the arbitration, and he will not be able to cause the company to recover for what it previously asserted that it was entitled to.
Thank you, David. Really complex questions arise. And I would like to ask Arabella, are there some questions which arbitration is just maybe not suited to resolve about insolvency? What is your view on that?
Well, I think slightly echoing what Andrew said, this is possibly not a question of who you ask, but possibly which country you ask. And I think there is a fairly big dividing line between those who see liquidators and other office holders as creatures of statute, and that the claims that arise are statute-based claims and are not intrinsically arbitrable. They must be dealt with by the court, their collective remedies for the benefit of all creditors. And there are countries that take a slightly more flexible approach. And I think this could probably be a topic for an entire session on its own. So I'm just going to look at three authorities very, very quickly, which I think illustrate the approaches that I've just mentioned. The first one is a Singapore case called Larsen Oil and Gas. And there you had claims being brought by a liquidator who was seeking to set aside payments on the basis that they were unfair preferences or transactions at an undervalue. And the underlying agreement under which those payments had been made contained an arbitration clause. And the court in Singapore held that as a matter of construction, the claim was not within the scope of the arbitration clause. And even if it had been within the scope of the arbitration clause, it was not a claim that was arbitrable. And the construction point was decided on the basis that when a company is solvent, its management is rightly concerned about private remedial claims. And if they wish those to be dealt with by arbitration, then that is a bargain that should be honoured. But once a liquidator is appointed, the management really is indifferent. And absent express language to the contrary, an arbitration clause would not cover liquidators' claims of that nature. And when it came to look at the arbitrability point, the court held that the statutory avoidance provisions were there for the benefit of all creditors, and that objective would be compromised or could be compromised if a company's pre-insolvency management could really dictate the avenues for enforcement of those claims which arose post-insolvency. And those claims could, of course, and often do, include claims against that former management itself. And those considerations, the Singapore court held, really overrode the freedom of the company pre-insolvency to choose the forum in which those claims ought to be determined. As against that, you have the position in England, which is in a way the polar opposite. The two decisions there that I have looked at are Norrie Holdings and Critty, and River Rock Securities and the Bank of St. Petersburg. Now, both those were cases which involved an application for an anti-suit injunction. And the anti-suit injunction sought to restrain foreign proceedings which were alleged to be in breach of an arbitration clause. And in both those cases, the argument was, well, the foreign proceedings involve insolvency claims, so they either don't fall within the arbitration agreement or they're not arbitrable, i.e. following the line of reasoning of the Singapore court. Now, in both those cases, the court said the construction point did not form part of English law. And what you have to do is focus on the nature of the particular claim and whether it's capable of being determined by arbitration, and not get hung up on what sort of a claim it is. And in Norrie, there was evidence that as a matter of Russian law, the claim would be characterized as an insolvency claim. In River Rock, the court went slightly further, and the court there rejected the construction point, even though the claims would have been regarded as insolvency claims as a matter of English law, and also held that that of itself did not make them unarbitrable. And there you see the well-known principle of modified universalism coming back into play. The evidence there was that if the arbitration was successful, the office holder would distribute recoveries to all the creditors in accordance with the bankruptcy scheme in Russia. And therefore, there was no reason in principle why the arbitration should not continue. Now, I haven't found any cases specifically on point here in the BVI, but the BVI has, of course, very firmly endorsed the pro-arbitration approach laid down in Fiona Trust and Privalov. So I think that would give some basis for anticipating that the BVI court would follow the River Rock and Norrie Holding line of reasoning rather than the slightly more trenchant approach adopted in Singapore.
So thank you so much. We're approaching the end of our event. We have about 8 minutes left, and we have 2 questions. But before we address those questions, which would be great if we could, maybe we could, each of you could just say a very, very short, like one line, what is the takeaway from this discussion? Now, what is your conclusion? I don't know, we can start with Arabella, with you maybe. What is your like one line takeaway?
We've got to sort the mess out. What is left of the Sparkasse test? Is it now the Sparkasse test, or is it the Fantasy Ruritania test, or some modified version of it? We need an answer.
David, what do you think?
Well, I think probably, having listened to everybody at the moment, I think where I'd come out is I'd probably say, based on all of that, it's probably safer to serve a statutory demand, because otherwise you could send your client on the way to a bloody nose and a bill when the court says you can't do that.
Thank you. Andrew, what are your thoughts?
I agree with all of that. One thing that Arabella said a bit earlier was that in Lenox and Rangecroft, the speediness of the arbitration was a factor. And it was in Lenox and Rangecroft. Arabella served as the arbitrator. She's been far too modest to say so. And she produced a scholarly award, if I may say so, within about 4 weeks. What was interesting in that case was that the judge was prepared to say, although there isn't a BVI arbitration clause, he's going to force the parties to arbitrate in the BVI. And in his subsequent decision, he said that the speediness of Arabella's award was a testament to the skills that the BVI IAC has. So I think my main takeaway is that in addition to there being some confusion about whether a statutory demand is needed, there is also a bit of confusion about the extent to which a speedy arbitration is a factor in dismissing or otherwise an application.
Thank you. And John, what is your takeaway? What do you mean?
Let me tell you what I would say. As I mentioned, I've had some experience with arbitration issues involving the BVI, from enforcement of the award, from resisting enforcement of the award, from arbitrating, from being an advocate. I think that an event like this is really, really important. And I think in a way, not so important for those who are attending who are from the BVI, but from those outside of the BVI who are looking in. Because what we highlight here is a very competent, sophisticated bar. There might be some inconsistency in the judicial decisions, but I think that's the case in any jurisdiction that evolves law in that way, as we do in the U.S. as well. And in that sense, I think that the event has been very, very, very successful. Because one of the things you want to do, right, is you want to be, you may say you have the model law, you have this, you have the other, but the judiciary doesn't function well. You have to look very hard for competent counsel. And I knew before this that all of this was present in BVI, but I think that the participation of the panelists, the reference to the source material, indicates that that this is a very good jurisdiction for considering resolution of claims through arbitration.
Thank you, John. So we have 2 questions, and I think one, John, is for you. You've mentioned that it would be great, to have this kind of that it would be a good idea for the court to have a checklist of 7 defenses. And Christina Hripkova is asking this question. Is there any known case law where an insolvency court checked 7 defenses in the New York Convention to recognize a foreign arbitral award as a proof of debt?
I would say, I would actually refer you to the Kirkland judgment. The judge said that, if my memory is correct, he really wasn't going to do it, but he did it anyway. In other words, he looked at the proof offered and he went through 7 categories of defenses, and he decided effectively, even if I were to do it, there weren't any, and so we're going to proceed. If my paraphrase is correct and my memory is correct, and that might be a good place to start.
Great. And we have a case from Mark Forte from Conyers, who participated in the Rangecroft, and he said, so that he's confused, and his question is, how do you get to honest belief without the sparkasse argument being advised in effect anyway?
Shall I attempt the answer to that one? The sparkasse test obviously has 2 limbs. One is whether there's a substantial defense, and one's whether there's an honest belief. And it does seem to me that the honest belief brings in the other limb by default, because if it's a completely hopeless defense, you can't have an honest belief in it. And I think that is the line that Justice Jack was treading in a creditor, or the Ruritania case, as Arabella calls it, because he was trying to tread a line between saying that a claim which was a good claim, which had no genuine defence, should be dealt with through the winding up process, and the parties shouldn't be exposed to the $2.389 million worth of legal fees associated with the HKIAC. So I think that's probably the answer.
Well, thank you very much. We have literally 1 minute left. There is a comment from James Dingra from Singapore saying, thank you to all of us. He says it's a very insightful discussion, well presented facts and concepts, and very good food for thought. I can only agree with that and thank all the panelists. I would like to remind that we are all in the BVI members of the BVI Arbitration Group. I would like to thank you, that group, and especially the BVI International Arbitration Centre for making this event happen. This also event is supported by ARBINSOL, and this is a group of people who enhance research in this field. And John Rooney is a founder of this group. And also I would like to say thank you to RCAN, which is an association and network of practitioners who are focused on the Russian and CIS speaking clients. And finally, I would like to say thank you very much to all of our attendees who I see are from various countries: Lithuania, Ukraine, Singapore, BVI, Miami, and it's really great to have everyone, and of course London, here today. So thank you again very much for your time, and I hope we have made things a little bit clearer, or at least identified where the problem lies. Thank you so much.
Thank you.
Bye.